We are here this afternoon for the submission of two cases. The first case is Iowa Department of Natural Resources versus Lilly and Global Fiberglass. And it looks like the parties are ready. Mr. Kruse, you may begin.
Good afternoon, Your Honors. May it please the Court. I'm Bradley R. Kruse on behalf of the appellants Ronald Albrecht and Donald Lilly. We're here today because the district court failed to establish any prima facie, or failed to establish any prima facie jurisdiction over the defendants. And in so doing, the district court found that the responsible corporate officer doctrine, a doctrine that has never before been adopted in the state of Iowa, applied in this case. And they found that it applied, determined solely on the basis that Mr. Albrecht and Mr. Lilly were corporate officers of a company that was alleged to have violated Iowa Code Section 455D, which is a recycling statute and that relates to solid waste eventually. Moreover, the district court erred because there was no analysis or treatment whatsoever regarding Iowa Code Section 455D, the operative statute. The district court merely found that because because Lilly and Albrecht were officers of the corporation that was alleged to have engaged in the conduct, that they were personally liable for the conduct so alleged. Going on, the other problem with the district court's ruling is the district court went on to erroneously base jurisdiction over, or personal jurisdiction over Lilly and Albrecht by virtue of the fact that they had, district court had inappropriately applied the corporate, or the responsible corporate officer doctrine. And so we have one improperly based ruling leading to another one. And so even if the corporate officer doctrine was properly applied here, or that Albrecht and Lilly otherwise had personal liability for the conduct complained of, that certainly doesn't mean that the Iowa District Court had jurisdiction over Mr. Albrecht and Mr. Lilly, who both are non-residents of the state of Iowa, both live 1,700, 1,800 miles away, and had no personal contacts in the state of Iowa and had no minimum contacts. Yes.
Motion to dismiss stage. And in response, or in support of the motion to dismiss, Mr. Lilly and Mr. Albrecht both filed what are pretty cursory affidavits, I would say. They basically said that they were not personally involved in the transactions and the conduct. If we were to adopt the responsible corporate officer doctrine as the district court suggested, is personal involvement required to establish at least liability?
I believe so, yes, Your Honor. Otherwise, you've got a complete evisceration of the corporate shield doctrine.
There's a difference between vicarious liability or otherwise, or piercing the corporate veil and applying the responsible corporate officer doctrine. It seems like even in part the Supreme Court said that liability did not depend on the knowledge of or personal participation by the officers in that case, a criminal statute. So do the defendants need to present more than the fact that they were not personally involved to avoid liability in this at this stage of the game, at least?
Well, I think there has to be some allegation that to have personal liability, that they engaged in some sort of improper conduct. Otherwise, what you've got is sort of a duty to affirmatively act to stop a corporation from doing something, and I find no.
what the responsible corporate officer doctrine is?
Well, it's not really clear what it is before us right now. It's not clear what version of the responsible corporate officer doctrine the district court sought to impose. It's not clear whether they were even imposing the responsible corporate officer doctrine. The state argues that that Lilly and Albrecht have liability under specifically under Iowa Code Section 455D, which I would contend is not clear either. Yeah.
What Justice Oxley was asking. I mean, if Albrecht and Lilly, if they had been actually involved in, taking this turbine waste and disposing of it improperly, if they were personally involved, there's no question they could be sued, right? You wouldn't need a responsible corporate officer doctrine because they would just be responsible for their personal misconduct. So the responsible corporate officer doctrine, I agree, I'm not totally clear in my head on what it does, but it doesn't mean you have to be personally involved. It allows you to go after officers because of their position, whether they were the ones that were personally committing the conduct or not. So I'm not sure that your affidavits in this case get you as far as they need you to.
I would agree with Your Honor, and I'm certainly not attempting to argue that you can never hold, that the state could never hold an officer of a corporation responsible for the acts of a corporation, and that the corporate shield is a complete protection against any of that. The problem what we have here is there has been no allegation by the state in their petition as to what exactly Albrecht and Lilly did that was wrong. And the district court ran with that, didn't make any separate findings, and just seemed to conclude that they were personally liable because they had been named in a lawsuit as defendants and because they were officers and directors of the corporation.
This is just a motion to dismiss. I would agree. This is, for me, from a personal jurisdiction perspective, this seems to me as an extremely skimpy record. And it's, what if we just said, okay, we affirm the denial. There's nothing to prevent you from renewing your motion to dismiss for lack of personal jurisdiction on a fuller affidavit. And state, maybe you better get around to taking some personal jurisdiction discovery instead of just standing on your petition, which is normally what happens in these personal jurisdiction interstate disputes. I mean, in some of the cases that we have, Roquette America, I think they went to France and took the depositions of these people before the personal jurisdiction issues were resolved. So, yeah, what if we just did that? What's wrong with that?
I wouldn't have a significant issue with that, Your Honor. And one of my biggest concerns and issues with the state's petition is there's just no allegations pled regarding minimum contacts. There's minimum contacts. There's no allegations pled regarding what Albrecht and Lilly did. I'll give you an example. It's a case that's cited. It's the Santa Rosa case that's cited by the plaintiffs in their brief. Well, in that case, the corporate officer was held personally liable, but had engaged in purposely directing conduct that was fraudulent against Iowans. And personal jurisdiction wasn't at issue there because it wasn't an out-of-state defendant. I think there was already jurisdiction over it. And certainly under circumstances like that, when a corporate officer engages in tortious conduct or directs his or her corporation to engage in tortious conduct, or if we were at a situation here where my clients, rather than just not getting around to recycling blades that at some point became determined to be solid waste, let's say they were they were purposefully disposing of hazardous chemicals or raw sewage in the waterways of Iowa, and they were directing that, and they were deliberately and intentionally committing those acts. That's a different situation, and I wouldn't be making the same arguments here, but we don't have that situation here.
We know what situation we have. And so me as a judge, I kind of sympathize with what Judge McCall did, because not really knowing what went on or what happened, conclusory affidavit, no discovery, I'm hesitant to just throw the state out of court on that record. That's at least my kind of initial feeling.
Can you address the fact that Mr. Lilly did sign the administrative consent order with IDOT? How does that play into whether or not there's personal jurisdiction with respect to him?
I don't think signing the consent order in any way, shape, or form creates a minimum contact or otherwise should be deemed to relate to personal jurisdiction over him.
The responsible corporate officer doctrine with respect to at least reflecting that he must have some responsibility with respect to these blades that are in Iowa.
Blades had gotten to a point where they had not been removed, and then the DNR notified the corporation that these blades were being determined to be solid waste at this point and that they needed to be removed. And so Mr. Lilly, on behalf of the corporation, signed a consent order that had terms in it that under which the DNR would, I guess, forbear, from lack of a better term, for imposing penalties and fines, giving them more time to get rid of the blades. But there's nothing in the consent order that somehow talks about personal liability or talks in any way about personal jurisdiction or should be deemed to have been.
That reflect that he at least has some authority and responsibility within the corporation if we're looking at the elements of the responsible corporate officer doctrine?
We don't deny that he had responsibility to make corporate decisions and that he was a corporate decision maker. And certainly with respect to the consent order, he did.
The particular issue that's going on in Iowa, right?
He was a corporate decision maker, and he did sign the consent order, but he didn't come to Iowa to sign it. And I don't think just the signing of the consent order, which was essentially an administrative act to deal with the ongoing issues with the DNR.
He was the person at the corporation that was signing this as being the responsible person. And if it turns out that he's the one that, has authority with respect to what the company does when they're disposing of these blades, does he need to come to Iowa under specific personal jurisdiction? The corporation has to act through some person. And so if he's the responsible person, why can't that be enough to satisfy personal jurisdiction?
Well, because if you're a responsible person under a corporation, then every individual that's a responsible person under their corporation is personally liable for any and all acts that their corporation may perpetrate and engage in, and that is well beyond the Iowa statutory framework that governs the relationships between officers and directors and their corporations. It's well beyond judicial interpretations of the corporate shield doctrine. It creates a whole Pandora's box of all sorts of,
More about the personal jurisdiction part. You seem to be talking now, and I think that that's a valid point, is how broad is, if we're going to recognize the responsible corporate officer doctrine, how broad is it? And is that what you're referring to when you're talking about liability?
So what we think the district court did is essentially equate personal liability with personal jurisdiction. They're two different things. So we don't agree, as a threshold matter, that Albrecht and Lilly have personal liability for this conduct under an application of the responsible corporate officer doctrine or under an application of Iowa Code Section 455D. That's the first threshold matter. But even if you think that they somehow do have personal liability for that conduct, if you think the responsible corporate officer doctrine has been properly applied, it doesn't equate that you should have, that the district court in turn has personal jurisdiction over, yeah.
You there, that those are two separate hoops that we need to get through. But again, I get back to my point, not really having anything in front of us and not really understanding or knowing the situation, what these two people do in the company. You know, why not affirm what Judge McCall did, but with the notion that you could renew your motion later on or with a more developed record?
More incumbent upon the state to refile their pleading rather than to make us guess what they're trying to do. They put this thing into motion in the first place and didn't properly, in my view, with all due respect, didn't properly plead it. They've had an opportunity all this time to do so, and they haven't done so. So we shouldn't be at a point where we're guessing about what they're.
Adopt the responsible corporate officer doctrine, and we get past that threshold determination, why wouldn't Lily's signature on the consent order be enough to establish personal jurisdiction under Harding versus Sasso, which seems very similar on the personal jurisdiction question with respect to him?
Because I don't think that simply signing a consent order or like a settlement agreement, if you will, with a state means that you, as a corporate officer, who may not have even been aware of what conduct was going on or that there was an issue at the time that it happened, and simply signing on behalf of a corporation as an executive officer or somebody with authority to sign off, I don't think that should be viewed as giving personal jurisdiction over that person. It's just not enough of a minimum contact. I guess to say it another way, Your Honor, it's just not enough of a minimum contact type of conduct or
Harding, we said it was. That a dispute relating to the contract at issue is sufficient to give personal jurisdiction in the state of Iowa if it was contemplated that some of the conduct in the contract, which this is essentially a contract, would be done in the state of Iowa.
Well, I still think it's distinguishable because of the nature of the consent order itself, and I can't go much beyond that, but I think it's a little bit distinguishable.
Come up again.
May it please the court, counsel. I want to start with the issue that took up a lot of the questions to my friend on the other side, and that is to agree that this is an interlocutory appeal of a denial of a motion to dismiss, and more importantly, it is denial of motion to dismiss in a notice pleading jurisdiction, where nearly any, for motions to dismiss are disfavored, nearly any complaint will pass muster. And as our brief suggests, to the extent there are concerns as far as whether the allegations here go beyond the motion to dismiss stage, that's a summary judgment issue. And in fact, that's why we see most of the cases that address the responsible corporate officer doctrine, they are at the post-trial stage, the summary judgment stage, or judicial.
Valid point that you have to get past it's not just a question of whether Lilly and Albrecht are responsible officers that can be liable. There's also the problem they don't live in Iowa or really have much to do with Iowa apart from their potential involvement in this matter. So you do have to establish personal jurisdiction. And my understanding of the way you review personal jurisdiction is the allegations in the petition are taken as true. The factual allegations is true, except to the extent they're contradicted by affidavits, evidence put forward by the party attempting to dismiss. And then if you can't just rest on those allegations if they're contradicted, you have to introduce some evidence yourself. There's no evidence really coming on your side apart from this consent decree, right?
Couple of points to push back on that. With the motion to dismiss standard itself, it's not that the facts alleged in the petition are taken as true unless contradicted. It's facts in the petition plus uncontradicted statements from defendant, and even then it's construed in the light most favorable. But
they're contradicted by evidence from the defendants, then you can't just rest on allegations in the pleading.
actually backward. It's to the extent that defendants introduce additional facts, those additional facts need to be uncontradicted. And
Correct. I don't think they get to put in evidence, and you can just rely on what you say.
the point is, if there's an issue in the pleading, that then is sort of a fighting issue for the litigation. But to get to the more factual point, which I think is kind of the more important point here, putting aside, how we kind of weigh this, if we look at the allegations in the petition, it's not simply the consent decree. There's also additional responses to the IDNR letter of inquiry. So in particular, the key allegations here are at paragraphs 50 and 59. So 50 talked about the company's response to the plans for processing the turbine blades, and that there were past contracts and involvement of both Mr. Albrecht and Mr. Lilly in recycling these blades and processing them. And then there's also the consent order there. And if the court were to look at some of the other jurisdictions that have addressed the responsible corporate officer doctrine, things like contracting with vendors to deal with a particular environmental issue are facts that lean toward liability and jurisdiction there. That's the Rolfink case out of Wisconsin, and the GR.
Albrecht, is it just that purchase contract? Is that it?
That is currently within the petition, to the extent there are concerns about either defendant, but Mr. Albrecht in particular. My understanding is there are other kind of contacts and communications that exist. So at minimum, the state would be asked for an opportunity to amend to add in that additional information. Part of what's important to remember here is, the state was working with kind of an uncertain situation where the court hasn't adopted yet the responsible corporate officer doctrine, though we would ask this court to do so as we have here, but then didn't have kind of the parameters of what this court says the standards are, and is still, again, operating in Iowa's notice pleading rule. That makes it distinct from especially other cases that my friend on the other side cites in the brief, which are, to the extent they even deal with environmental statutes and the responsible corporate officer doctrine, they deal with federal pleading standards, which are much higher. So it's important not just that we're at a motion to dismiss, but we're at a motion to dismiss stage with a very liberal pleading standard. And also the idea that we're in this environmental realm where we also construe the law, we give them liberal constructions. That's in the DeCoster case.
Doctrine itself, the liability theory, what would distinguish it in this environmental law context from kind of any other civil violation context? And I guess I'm concerned about piercing the corporate veil, so to speak, and holding corporate officers responsible for their failures to present. I think that's the theory, right? Like the failure to prevent the entity from doing something in violation of the law. What's the limiting principle or theory behind that?
First off, as a threshold matter, this is a distinct theory from veil piercing. This isn't a case where we're talking about there being an alter ego, not having a bona fide corporation. But there are some overlaps in terms of these are often undercapitalized companies. However, as far as the doctrine itself, and it's important to note that with respect to the doctrine, this court isn't acting on a blank slate. This has been an established part of federal environmental law for 40 years, and no state has considered the doctrine and declined to adopt it. So if this court were to reject the doctrine, it would be the first in the country to do so. And so we're looking at this kind of established kind of view of the doctrine that looks at, there's various self-limiting principles. First, it has to be a public welfare statute, when that needs to be clear from either the text or the stated intent. And we see that in Iowa's environmental statutes, that these are essential to protect the health, safety, and welfare of the people of Iowa. And that kind of goes to one of the policy purposes of the doctrine, this notion that these are statutes where the public is ill-suited to protect itself. But I think another very important limitation is that it only applies in strict liability violations. And that's why we're largely only seeing it at the state level in these environmental statutes, where most environmental statutes have that structure. We also see it in the kind of the food and drug safety at the federal level, but that's sort of a more unique area of operation of the federal government. So we're looking at this specific subset of statutes, and then it only applies to a specific subset of individuals. You know, you need not just the position within the company, but you need kind of the nexus between the position and the violation, and whether actions or inactions facilitated the violation. And I think this point goes to the personal jurisdiction versus liability issue. Given this nexus point and the action and inaction point, I think factually, it's difficult to imagine a world where you'd satisfy those elements of the doctrine, but then not also have minimum contacts. It's sort of,
I'm not sure about that. I mean, it does seem like, you know, I follow your argument, assuming these are folks, this is a company based in Iowa, but I'm not, even if you apply this responsible corporate officer doctrine, I'm not convinced that you don't have to go to Texas or wherever to sue these folks, because it does seem there's a serious maybe due process issue where you have somebody who's only acted in their representative capacity. Again, I don't really know the facts, so maybe the facts are stronger than they appear to be. But and then you're saying that they can be subject to personal liability in the state of Iowa and required to defend their own personal liability in Iowa. That seems to me maybe raises significant due process issues. I don't know.
extent we're talking that, you know, the individuals must be present in Iowa, I'm not sure that this court's ever held that. In fact, if I'm thinking to the recent case in TikTok, certainly TikTok, ByteDance, those employees weren't present here in Iowa. But
Employees there, you're suing TikTok.
I think the same logic applies if we look at this notion that we have individuals that are seeking to monetize their contacts with the state. So if we take a step back and look at the facts that are actually on the ground here, these are companies operated by these individuals that amassed more than 1,000 wind turbine blades and were storing them at locations throughout the state of Iowa, entering into agreements with individuals in the state of Iowa, then violating their obligations with respect to those blades.
Earlier point about monetizing their relationship with Iowa, isn't the CEO of TikTok or all those little TikToks, aren't they in the same situation as here?
Well, there's certainly a difference in terms of if we're talking about whether the responsible corporate officer doctrine would apply. TikTok was a consumer fraud case, and kind of tortious statutes and consumer fraud statutes do operate differently. As I said, when we're looking at the responsible corporate officer doctrine specifically, we're looking at those public welfare statutes, strict liability statutes. So while there's certain that overlap in terms of some of the policy considerations that this court has looked at, I agree that there are kind of differences because we're looking at different types of statutes.
Work in the business of taking care of these blades, right? Then the CEO of TikTok would be on the line in all 50 states for conceivably.
And I think that'd be difficult under the kind of the facts of how the two companies operate. Because if we again look at what we have to show under the responsible corporate officer doctrine, it's not enough to go to the Secretary of State website, look at the corporate filings, and just list whoever's on those filings. You also have the nexus requirement and the action or inaction requirement. So you're not going to see it generally with a big corporation, where you've got lots of layers in between, say, the CEO and kind of the individual people involved. Whereas,
Question. You cited the Santa Rosa case as sort of strong authority for this idea that we're close to adopting this doctrine. And in that case, you emphasized the complete control aspect, but we also talked about the own personal acts of, in that case, it was a consumer fraud situation. But would it be reasonable for a state to consider sort of that idea of actually just sort of limiting the doctrine to action as opposed to action or inaction, if you will?
at a separate doctrine of corporate responsibility. We kind of see as we look at these cases, there are sort of three buckets. They're veil piercing, responsible corporate officer doctrine, and direct participation, with the latter being something we see almost exclusively in tort cases. And the Northeast Pharmaceutical case and the Doherty and I believe it's the RLG case, those all kind of talk about the distinctions there. So certainly that would have been a factor in Santa Rosa as a consumer fraud statute, yet the court there did still rely on not just this notion of control, but specifically cases that applied the responsible corporate officer doctrine. That was the Cattle King packing case and the Kailua Auto Records or Wreckers case as well.
Administrative consent orders. I suppose one argument is that Lilly signed them, so maybe that supports the exercise of personal jurisdiction. But I guess on the thought of the responsible corporate officer doctrine, if the state was concerned with making sure that he was subject to personal liability, why didn't they just include him as a party in the administrative consent order versus only having Global be the party to the order?
Speak to kind of what that agency level decision was, and it might be, and this is something we see in these responsible corporate officer doctrine cases, is that generally, the instinct is to continue to work with these companies to the extent they're cooperating, they're properly capitalized, to try to, because the ultimate goal with these statutes is to remedy the problem, to get things cleaned up. So they were working with GFS, but also Mr. Albrecht and Mr. Lilly, and this is, I think, one of the things that to the extent, there were a motion or a requirement to amend or additional factual development and discovery, you'd see that these were individuals that were the key point of contact with the regulatory entity, and this was a key point in some of these other cases. In particular, the cases out of Washington, Lundgren and McNamara, as well as, I believe, also Doherty and RLG. Those are cases out of Minnesota and Indiana, respectively.
This is a sort of understanding how the agency works. Are there sometimes these orders, these consent orders, do they sometimes include provisions that resolve the jurisdictional issue, like I'm consenting to jurisdiction as part of entering this order?
Well, I can't say for certain, just intuitively, given that these sort of operate similar to kind of settlement agreements, and we kind of see this in some of the language there in Exhibit 1, that there's no admission of liability, or that any of this happened, I think that'd be very unlikely that an entity would willingly agree to that. But
Part of that.
they could have gotten an agreement, but generally, too, what we see is in some of the sorry, I might see my time's expired, may I?
Sir.
One of the issues here that actually resulted in the liability, because again, we start from the premise of the department wants to just resolve the issues, was the failure to then comply with this agreement to resolve the issue. It was the subsequent inaction that occurred once, this was entered into. So I'm not sure how they, the department, I think, generally likes to assume people are going to do what they say they're going to do. So the idea that they would then backstop would be a little unusual, to say the least. Unless there are any other, we'd urge the court to adopt the doctrine and affirm the district court's denial of the motion to dismiss.
Thank you, Your Honor. Just address, first of all, some of the things that counsel referenced. With respect to the 8 or 9 states that have adopted the responsible corporate officer doctrine, I would point out that it is just that. It's 8 or 9 states. This is by no means the majority of jurisdictions have adopted this. The other thing,
Are you aware of any states that have considered it and then chosen not to?
I'm not. I'll take her at her word for that representation, but I will also point out, and I think it's important, is that most, I think, if not all of these states that have adopted it have adopted the doctrine legislatively, not necessarily just judicially. And one of the problems we have as we sit here, if this is the seminal case to adopt the responsible corporate officer doctrine judicially, it's very vague and unclear based on the pronouncements by the district court as to how broad this is. And again, I can't emphasize this enough, the district court did no separate analysis of Section 455D, the very limited solid waste statute that the state says has language in there whereby you can hold an officer personally liable.
Provisions of 455 that do talk about individual liability. Like they define persons to include the corporation, their agents and officers.
We do it quite as cleanly, Your Honor. It says, and it's a little vague, 455D I think is vague in and of itself. 455D 22 says that a person may be liable. It doesn't say any person. I think that's somewhat of a meaningful distinction because in other places in 455D, the statute talks about owners and operators. So clearly the legislature in enacting 455D understood that you could, the distinction between a natural person and a corporate entity. And in fact, they talk about both.
Let me put it this way, because I think your dialogue between the two of you is getting an important point. Listening to the state's presentation, one gets the impression that this responsible officer doctrine is like a rule of common law, and we're kind of the kings and queens of common law. We can do with common law what we want. Another perspective would be that, and maybe a more valid one would be that we're really interpreting this particular environmental law, and we have to look at we have to give a fair reading to this environmental law. Who does it subject to liability? And if that's the question, then maybe we should be focusing more on this particular law and less on what some other state might have done under their own laws.
Disagree, Your Honor, and the problem that we have with the district court's ruling is the district court did not focus in any way whatsoever on 455 and interpreting 455D. The district court seemed to be just looking at the overall responsible corporate officer doctrine, whatever that may be, in a very broad context, gave very little analysis as to why it was being applied and to the extent of its application, how far does it go, what all does it apply to. And so that's the record that we have before us is the district court's application of the broad doctrine with no specific reference to 455D whatsoever. And so again, I think
Practical consequences, if we affirmed on this thin record, what impact would that have on other businesses' willingness to operate in Iowa?
a major negative impact on businesses, not only businesses outside of Iowa, but Iowa businesses as well. I mean, not only are corporate officers and directors of corporations that might have engaged in either illegal conduct or violated a statute, not only are they personally liable for encouraging the corporation or being involved in the corporation's engagement of that conduct, but they would have an affirmative duty to prevent that contact. It goes beyond that. And that was a point.
Going the other way too, by going the direction you're asking us to, couldn't it also encourage high-flying CEOs to conduct all of their business outward, sign papers, and do all kinds of things that might be considered detrimental to the environment of Iowa or somewhere else?
Swings quite that far, Your Honor. It's a fair question, but I think the state already has mechanisms in place to prevent that kind of conduct. It's not carte blanche that a CEO can willy-nilly do anything and hide behind the corporate shield doctrine. You have the ability to either pierce the corporate veil. You have the ability to make allegations that this particular CEO or executive knowingly violated statutes, knowingly violated the public welfare, knowingly committed tortious conduct or directed his company to commit tortious conduct. And if you have that information, well, then plead it and prove it up. And that's fine. The state already has a mechanism to address those kinds of situations. They don't need a broad, undefined, responsible corporate officer doctrine that virtually opens up a Pandora's box of liability for corporate officers and directors of Iowa corporations or otherwise. And I think, to Your Honor's point, it would be very detrimental to business in Iowa. Just that, just for all the reasons I've stated, Your Honors, we would request that the motion to dismiss be overturned, and that Messrs. Albrecht and Lilly be dismissed from this case at this time.
DNR versus Lilly and Global Fiberglass Solutions is hereby submitted, and we'll have a brief pause here.